Welcome. Good afternoon. My name is John Stenhouse. I'm the Business Support Manager at the University of Essex University Enterprise Zone. And we run programs on Angels at Essex and Space to Grow for investment readiness for those businesses who are keen and eager to raise equity finance or other kinds of finance for their seed enterprises, their innovative ideas. And that is our role. What is the University of Essex? The University of Essex is an established university. It's been around since the mid-60s, and we have been offering help and advice to businesses for some years now. And our programs under the Angels at Essex banner, the University Enterprise Zone, are targeted at SMEs, those smaller businesses who wish to grow rapidly. They are innovative in nature and they've got good ideas. And with that come complications. And life is never easy, and you always need to phone a friend or ask the audience for some kind of help and advice as you're going through this process. So with us today, we have Queen Mary University of London, their legal team, led by Emily Wapples, and their students who are here to listen to your questions and to help and offer advice, although it's not regulated advice, I will hasten to say. But I will let Emily introduce herself. Emily, over to you, please.
I'm Emily Wapples. I'm the project manager at qLegal. So qLegal is part of the Centre for Commercial Law Studies at Queen Mary University. And we work with students who are studying for their law masters. We work with around 250 students this year to help them develop the legal and practical skills they need to thrive as innovative lawyers for the future. And in doing so, we get to help startups like you to provide legal support to your business needs. And one of the ways we do that is through webinars like this. So without further ado, I'm going to hand over to our wonderful students who are going to deliver the webinar on intellectual property rights for you today.
So good afternoon. My name is Azizat Piriola and I'm studying my LLM in intellectual property law. And with me are my colleagues.
My name is Akansha Yadav and I'm doing my LLM in comparative and international dispute resolution.
My name is Li Bingyan and I'm a student of intellectual property law.
My name is Yuan and I'm doing intellectual property law.
So today we are presenting on that qLegal. You've heard about qLegal before. So qLegal is an award-winning legal service, and we provide free legal advice and resources for startups and entrepreneurs. qLegal is a student-led, run by Queen Mary University of London, and we receive supervision from internal and external lawyers and supervision from legal professionals. So qLegal provides one-on-one written legal advice, like this workshop, one-on-one written legal advice. We provide public legal education, like this workshop, including externships and consultancy projects for businesses. Today, we're going to cover what intellectual property is, why your startup needs to protect its intellectual property assets. We're going to cover the various forms of intellectual property assets, starting from trademark to copyright, patent, trade secret, and design rights. We're also going to talk about how you can protect your IP rights when working with third parties, then following on with how you can monetize from your intellectual property assets. Please note, we are going to be focusing on UK law, and we are going to make use of the abbreviations listed on the screen throughout. Please note that this webinar is meant to be for information purposes only and does not constitute specific legal advice. If you do require specific legal advice, please visit the qLegal website to see details on applying to qLegal Legal Advice Clinic. Why does your startup need to protect its intellectual property? This is because intellectual property is everywhere, and you get to see that through this picture. Here you see a picture with a breakfast meal. This picture contains all we are going to be talking about today, that IP is everywhere. In the computer, we have different technical components that could be protected as a patent. Computer software could be protected by copyright under literary works. The images on the screen may also attract copyright protection as artistic works under copyright. Further, the shape of the mug and the bottle could be protected as registered or unregistered design rights. and there may be secret formulation process in how the croissant and the coffee is made, which makes it a trade secret. Lastly, there is a brand name on the tray, and that could be capable of gaining trademark protection. Thus, we say here that IP protects innovation, creativity, and expression of ideas in different forms. And this means that there can be more than one IP right in a business idea. So do keep an open mind when considering the intellectual property right in your business idea. The next question you might be wondering, how do you know what you can protect and how can you protect your IP rights? Next, we're going to cover the core elements of IP rights. And to help us with that, we are going to take everyone through the story of Young Innovative Team. So here is Tim, and Tim wants to create a cloud computing software service startup. He's developed a clever piece of computing software that he wants to market to customers. He plans to name his business TechNext and wants to create an app so that consumers can purchase his product easily. From a previous business he ran, he has developed a list of customers, and he wants to keep them because he feels they would be valuable to his business. He discusses his business with a friend who advises him to speak to a lawyer. Now, let's look at potential IP rights. The software he is planning to develop could fall under patent, and the process he has developed could be a trade secret. His business name TechNext could be protected under trademark. The design of his product could fall under design rights, and there is the potential that his software could also be protected under copyright works. Now that we've identified Tim's potential IP rights, I will hand over to my colleagues to take us to ways Tim can protect his business ideas through intellectual property, starting from trademark.
Good afternoon, everyone. In order to understand the concept of trademark, we're going to take you through the story of Tim and his journey with intellectual property. Tim wants to create his own startup called TechNext, where he intends to develop a software and license it. So coming to the basics, what is a trademark? Well, to define a trademark, it is any sign that is capable of being represented on the register in a manner which enables the registrar, the competent authorities, and the public to determine the clear and precise subject matter of the protection afforded to its proprietor, and at the same time distinguishes one's goods and services from another's. Further, the trademark needs to be distinctive, non-generic, and non-descriptive. Now, what does this mean? For example, the name Apple is descriptive if it is used for selling apples, but non-descriptive, non-generic, and unique when it is being used to sell electronic gadgets. A trademark may consist of words, including personal names, designs, letters, numerals, colors, sounds, shape of goods, or even their packaging. Yes, you heard that right. Even colors and sounds can be a trademark. Some of the very famous registered trademarks in this domain are the yellow color used for Post-it notes. This particular color is trademarked by the company 3M. The famous sound of roaring lions of the Hollywood film studio Metro-Goldwyn-Mayer, and our favorite, I'm Loving It, by the McDonald's. As my colleague earlier mentioned, we're surrounded by intellectual property and we don't even realize it. Let me explain you this with an example. Imagine you're on a road trip and you're feeling hungry. As you continue on your trip, you see a giant yellow M sign, which brings you immediate happiness, as you now know that McDonald's is in the vicinity. You figured all of this by just seeing a M sign. Now that sign is what we call a trademark, and it fits well in the textbook definition of trademark. It is a sign which can be represented, and it distinguishes its goods and services from another competitor. That M sign is a registered trademark of McDonald's. I'd like to pose a quick question to you. Well, considering the scenario that I have told you about Tim, do you think Tim can get the trademark TechNext registered? So to clear some doubt and give you a more definitive answer, I would say that before he starts with his application, he needs to make sure that the particular trademark that he wishes to register is not already a registered trademark. Now, how does one do that? In order to do so, he can do a preliminary search on the link mentioned on the slide. to make sure that he is not infringing someone else's registered trademark? Well, if he would have done a preliminary search on the site mentioned, he would have realized that TechNext is already a registered trademark. Well, so Tim is smart. Keeping in mind all of this information, Tim did decide to change the company name to New Tech. Now, while we're on the topic of a registered and an unregistered trademark, I would like to tell you what exactly is the difference between the two. The proprietor of a registered trademark has certain rights over the particular trademark. No other competitor can use that trademark. And if any third party tries to make use of the registered trademark, you have the right to sue the third party for infringement and claim damages. With respect to an unregistered trademark, you might be able to stop a party from using a trademark similar to yours on their goods and services. This is known as passing off. However, I must say it is harder to prove a passing off than to defend a registered trademark. To prove an action of passing off, one needs to show that the mark is yours, while you have built goodwill associated with the mark, and that you have been harmed in some way by the other person's use of the mark. The validity of a registered trademark is 10 years from the date of application. And well, to continue to enjoy the benefits of a registered trademark, one needs to apply for a renewal every 10 years. As we're on the topic of registration, one question that pops up in our head is, how do we get our trademark registered? Well, to get one's trademark registered, one needs to file an application on the link mentioned on the slide. There are significant costs involved. The cost of filing an online application is about £170, and an offline application is £200. The cost of renewal, which needs to be done every 10 years, is £200. So coming back to the story of Tim and his startup called New Tech, Tim could register the name New Tech as a trademark, provided it meets the criteria we have discussed above, and that no one else is using it for the same goods and services.
So now we're going to talk about the app that Tim wants to build. And let's explain how Tim can protect his app through copyright protection. It is important to note that copyright protection extends to expression of ideas, not the ideas themselves. That means Tim's idea for an app has to go beyond the idea. He has to take preparatory steps in creating the app, such as getting app developers and writing down some information before he can protect his work under copyright. Once he creates the app, then he can protect his work as a copyright work. Copyright does not extend to procedures, which is better protected under patent, and more on patent will be touched upon shortly. The term works is used to refer to a number of intellectual copyright works, and this includes literary works, dramatic works, artistic works, published broadcast works, and also published editions. And these are the various types of works that could be protected under copyright. There are some criteria of protections for a work to be regarded as copyright work. This includes that the author has exercised some labor, skill, and effort in producing the work. And it is important that the work is original. You cannot copy someone else's work. Also, the work has to be preserved in some form of writing in a material form, although this is excluded for films and dramatic works because they are recorded as well. So essentially, some form of documentation that allows you to claim a right in the work when there is an infringement. You may be wondering whether copyright requires registration. This is an exception to the rule in IP, as copyright does not require a formal registration. In fact, there is no system for registering copyright in the UK. While it cannot be registered, it is best practice to indicate copyright in your work, just as it is on the screen, by including the copyright sign with the name and the year the work was created. But note, placing the sign of copyright on your work is not determinative, but it can be helpful to indicate that copyright could subsist in the work. Another thing is how long does your copyright work? Because I'm sure you've heard that trademark lasts for 10 years unless you pay renewals. Copyright is an exception as well. It lasts throughout the duration of the person who created the work plus 70 years. What this means for you is that when you create a work, it lasts through the duration of your lifetime plus 70 years after a person is gone. And there are some works that are excluded from copyright protection. This includes policy reasons, and it covers works that are obscene or immoral. The law regulating copyright protection in the UK is based on Copyright Designs and Patents Act 1988. Now, you may be wondering, what do you do with your right in copyright? As a copyright owner, you have the right to benefit economically from your work, such as authorizing reproduction and also restricting access to your work. It also comes with moral rights, which includes the right for you to be recognized as the author, and there are some exceptions identified with copyright. These exceptions are what we call fair dealing, and this allows us to use the work of others without infringing on their copyright. The exception applies based on the purpose for use, and this includes research or private study, criticism, review. For example, students and researchers are able to copy short extracts from a book without permission from the author, but they need to provide a reference.
My name is Living Yan. Now I would like to give you a brief overview of patent and trade secret. Patent rights is an intellectual property right that will give you the right to exclude others from making, using, or selling an invention for a period of time. This maximum period is 20 years. Smartphones are a perfect example for this. There are more than 2,000 technical patents behind the smartphone. Mobile phone manufacturers have gained substantial profits through patent exchanging and licensing. So let's talk about what does it take to get a patent. Let's back to our story of Tim. Tim would like to apply for a patent, which we have named it as beta. Beta needs to meet 3 requirements. The first one, it should be new, or we call this as novelty. And second one, it should involve an inventive step. The third one, it should be an industrial application. For the first requirement, novelty is strict. It requires that the invention never be known in any form, anywhere, before the filing date. So it's important to search the patent database before applying for that patent. Besides, if Tim has advertised the technology before filing the application, beta will never be patentable. Of course, if he noticed to sign a non-disclosed agreement during the business negotiation, that will be okay for this case. For the second step, invention step, this step requires for invention to be creative. In other words, the invention is non-obvious to a person who's skilled in the relevant field. For the third requirement, industrial application, it requires that the invention can be used in industrial field, including agriculture, which means the invention could be a product or improved method for industrial, but cannot be a purely logical or theoretical projection. You can either apply in UK Intellectual Property Office or through the European Patent Office, since UK is still a part of European Patent Convention after Brexit. And you could choose to obtain patent protection from the 38 EPC countries and pay for it. Now I have a question for you. My colleague Azita has told you that software is always protected as copyrighted work. So to consider the requirement I have mentioned before, do you think the software can be patented? In our discussion today, so my answer is that depends. UK and European patent law states that it is not possible to obtain a patent for computer program. However, if the software provides a new technical solution to a technical problem, that will be patentable. Besides, the US patent system allows software to be patented, but in practice, fewer and fewer could gain for patent nowadays. So with this question, I hope you will notice that 2 things. Firstly, patent rights are national rights. It is to say, an invention is patented in one country, That doesn't mean that the invention must be patented in another country. Therefore, if you want to obtain patents in different countries, you will need to search and apply in target countries separately. Secondly, patent law is very complex, and there are many exceptions to patent law. So it is necessary to have assistance of a patent attorney when dealing with patent issues. At the same time, professional lawyers can charge quite expensive. So for startups, the Chartered Institution of Patent Attorney help a lot. The institution holds regular IP clinics around the UK, and you could receive free basic advice for patent attorney. You can also consider seeking advice from our qLegal. Our other programs, such as legal advice, they may provide more targeted advice for you. I've put the link on the slide, and you can find them and our handouts too. Now I would like you to consider this question on the slides. The cost of applying for and maintaining for a patent. Because of limited of time, I won't let you to answer each of the questions. But the reason I put this question here is to recommend that patents is quite expensive. The UK application fee currently costs between £230 to £218. The annual fee for maintaining a patent increases yearly from £70 to £610 per year. In addition to this, you may need to pay for translation, search, lawyers, and lots of extra fees. The point I want to make here is not all inventions has economic value. If there are only a few buyers, the cost of obtaining a patent may be more than the money it will bring. Therefore, if you consider to apply for a patent, I would suggest a first research into the relevant market before, to ensure that invention has the ability to make a perfect. So let's make a brief summary about the points and cons for patent. A patent is a monopoly right. At the same time, it has economic potential, which means you can expect a certain financial return. But in order to obtain this monopoly right, you need to pay a lot of money and time needed. Besides, the life of a patent right is shorter than other intellectual property rights, which my colleague has mentioned before. The patent right is valid for 20 years from the filing date, but not the date of authorized. In other words, the real period you have of this right will shorter than 20 years, and this period is not extendable. In addition to the time and money spent, you may have paid another price to obtain a patent. That price is to disclose your invention, which means you need to provide a detailed description for carrying out the invention in your application. That is why some companies choose to protect invention as trade secrets, but not a patent. So our next question is, what is trade secret? In practice, choosing between patent and trade secrets is a complex issue. Trade secrets are defined as any information which has commercial value and has been subject to the reasonable step to keep it as a secret. As you all know about the formula of Coca-Cola and the Google algorithm are examples of trade secrets. However, you should notice that once the trade secret is disclosed, it will no longer be patentable due to the loss of novelty. And the technology that keep it as a secret may be applied by someone else, because patents are granted to the first person who fills the application. This is one of the risks of choosing trade secret for protection. And another risk is reverse engineering. This process is legally, and your secret will never exist. So at the end of my part, I would like to talk about how patents and trade secret can be used as commercial tools. My suggestion is to have a relevant market research first, and to set up your business plan, then calculate the potential revenue. After that, with the help of a lawyer, to make it clear which is the best option to protect your intellectual property. Is patents or trade secret the best one?
Good afternoon, everyone. My name is Yuan, and I would like to give you a brief overview of the design rights as the final type of intellectual property here. And as we all know, Tim has already handled such a lot of stuff and now wants to design the outlook of his product. So we come to design rights. First, let's have a look at what design is. Tim has successfully invented his product and has patent protection, but why do we still need design rights? And when were we involved in design law? So here we are going to do a poll, and my question is, which one is qualified as a design? To be honest, I think A is a trademark, but B and D is could qualify it as a design. And I want to talk about C, because C is a design drawing, and design drawing itself cannot be protected by design law, but if you want to protect it, you might can protect it as copyright. But if you use the C to be the design drawing to be to produce your own protection, and the protection can be qualified as a design and be protected by the design law. So let's talk about what is design. And if you want to use the most straightforward sentence to describe the design, we can think design is the intersection of technology and art. And when design transfers an original industrial production into an object with a beautiful appearance, which makes you feel excited, and it is successful. The design makes the final outlook of the product different from the other objects. And you have to keep in mind that it is not pure art because it must be applied to industrial protection. And now there is a question: how does design law work in the UK? To be honest, the design system in the UK now is quite complex, but we still have two most important design rights, and one is registered design rights and another is unregistered design right. So let's start step by step from the difference between registered and unregistered. So the first question is, what is UK registered design right? It is an exclusive right that ensures the property make or use or sell or input or anything to a product as long as it embodying the design, if it's a shape, or bearing the design, if it is the decoration. And this right prohibits the third parties from carrying out any of the rights without the permission. To obtain the UK registered design right, the property must fill a formal application to design registry, and if successful, the design protection can last 25 years, but should be renewed every 5 years, which means you need to pay the fee. And choosing whether to register your design is crucial because this registration indeed has various advantages. However, it also costs money. So some people prefer not to register their design. And the process of the registration, it is much similar to the design registration, as my colleagues just said before. So let's just clarify what will happen without registration. In general, even if you do not register your design, you can also protect it. Registration is not necessary to obtain protection, since the designer will automatically gain the right after the creation. But the question is, what is UK unregistered design right? It is also a right can prevent unauthorized copying within the UK, but it may really be infringed when the third parties produce stuff by copying the design. So it is no longer a monopoly right like the registered design right. And the test for assessing the infringement is highly linked to the individual characters. And now we're going to the protection. the protection is guaranteed to the designs must fulfill two criteria. The first one is novelty, and the next one is individual character. The criteria is judged with the reference to the existing designs available to the public before the effective filing date of application, which is much similar to the patent law. And the novel designs with air appeal could get protection in the British design system, or the systems modeled by the British design system. And you have to keep in mind that it must apply to the products. And before going, we still have some other rights. What I want to say is sometimes copyright and design right, they will overlap, and design right sometimes cannot protect some stuff in the UK, but it can be protected by the copyright. And now that we have mentioned earlier, Tim plans to pitch his business idea to the investors. So let's talk about how to protect the IP right when dealing with third parties. So the first step is you have to register your IP rights. And since you want to dealing with the third parties, register your IP right is better. And then you have to think about which parties you may face and who you may negotiate with. So the people can be involved with your IP, maybe employees, constructors, investors, and if it is more than one people with the IP right, it may also relate to the issue of joint ownership. So you need to use constructors to protect your IP rights, and it's very important because stipulate an employee's obligations and ownerships in your employment contract can avoid disputes in the future, and you can make clear that this investors' rights or shares in the business and have them sign a shareholders agreement that can make clear who owns the copyright. And you can ensure the constructors agree to assign or transfer the ownership of the IP rights to the business. And as for the joint owner, the parties should transfer their IP ownership to the company. And under the UK law, the IP created by an employee during the course of their employment will be owned by the employer if there is no opposite constructs. And if a third-party constructor creates the IP, the default position will be the constructor will own the IP unless there is an opposite contract. And we should mention the NDA. What is NDA? NDA is a non-disclosure agreement, which is legally binding the contract that establishes a confidential relationship, and the parties sign the agreement agree to sensitive information that they may obtain will not make available to any others. So it is very useful things, but we should also keep in mind that we cannot be too free with business information, because although we have already signed an NDA, we still have the risk to breach it. And if someone breach your NDA, that you could bring a lawsuit against them. By the way, qLegal's legal advice clinic can also help startups to prepare their NDAs. And if you have some interest, please do not hesitate to get in touch with us.
Sure that many of you must be wondering about the pros and cons of registration and protection of your intellectual property. Well, let me guide you through it briefly. One of the benefits of registering or protecting your intellectual property is that it sends a message to potential investors that your intellectual property is protected. and this may influence their decision to invest in your company. Another benefit of protecting your intellectual property is that you can commercialize it, that is, make money from it by way of assignment or licensing. Now, what is assignment and what is licensing? Assignment means selling your intellectual property right, and once you assign your intellectual property rights to another party, you cannot get it back. Whereas licensing your intellectual property rights is allowing others to use the intellectual property right for a period of time in return of payment of royalty. Well, there are three different forms of licensing: exclusive, sole, and non-exclusive. Well, exclusive is where granting a license to one party. This form of licensing excludes the licensor from using the intellectual property. It is similar to an assignment, except that in this scenario, your intellectual property is not sold off. Sole licensing is where the license is granted to one party, but the licensor can access the intellectual property as well. Non-exclusive licensing is granting license to multiple people. For instance, Microsoft licenses its operating systems to many people. To engage in licensing, the best practice involves putting into writing the terms and conditions of both the parties, the type of license, whether sub-licensing is allowed, the duration, territorial restrictions, etc. Now, talking about the disadvantages or cons of registering your intellectual property is the cost involved. To register a patent, trademark, and design, one needs to pay an initial fee and renewal fee to continue protecting it. Also, considering that a patent expires after 20 years, it may be better to protect the information as a trade secret in some situations.
So moving on, there's some practical consideration just to consider in terms of protecting your intellectual property rights, whether you decide to register or not. So you need to consider whether as a small startup, whether it is a priority to make that investment for your business. And this makes it an individual assessment. But a great tip is for you to treat your business as if it is protected, as this is the best way for you to ensure that you secure your intellectual property right, whether you register it formally or not. Now, that brings us to the end of the webinar. So this is a summary of what we've talked about. We've identified that intellectual property is everywhere. We've mentioned the various IP rights that can exist in a business idea. And we've discussed the various ways to protect your IP rights when you're working with others.
Camilo has asked a question: how to protect intellectual property in financial services, and what can one protect when you're using an established legal technique? Well, I believe it's a little bit specific question in terms of financial services, and I'm afraid we won't be able to answer it much in detail. But with respect to trademark, which is the section that I covered, I would like to suggest is while you're using any financial services, well, if you are initiating one or you're going to start up a financial service, I believe one of the most important things one can get is to register the trademark, as I said, which would be the name of the company or the name of the enterprise. So as long that in future, while you associate some goodwill out of it or you're in business, it may protect you from third parties using that name. So that's what I would like to suggest in the practical workings.
Obviously, when you're looking at financial services, there are different aspects, and the trademark is definitely the number one to look at. It's the systems that you're using, because if it's already being used elsewhere, then it's just copying. So therefore, you have to be careful you're not infringing on others. So the question from Anita.
Yes, so I would take up the one about existing idea. So that is relating to software protection, and I would say it depends on whether you get someone to develop the app and whether the kind of information they use to develop the app. So there is something called open source software. If it is an open source, then there is a limit on you gaining full protection over it. But since it's going to be a new type of app, you would most likely get copyright protection. And it's better to probably consult with a lawyer who is more a specialist in software development to answer your question in the best way.
And the question from Camelia about startup.
So the one regarding trademark already registered, if you're asking maybe the trademark you're trying to choose has been registered, then you will need to change it, because one of the elements of trademark as we've talked about is that it has to be unique. And if it has been used by someone else, then you can't use the name any longer. So you would need to probably, if it is similar with your own, you may need to contact the person so that they may allow you to use it. But the best thing to consider doing is changing the name and ensuring that it is a name that is not already trademarked.
We had another question come in from Sanjita Jain. So how about software tools still in the process of design and developing? So how would you protect that? To
protect the software tool, it's all about keeping it confidential up until you're ready to disclose it. So the way you protect your patent through trade secret before disclosing it, that's still the same way you get to protect your software, because the main element why you're trying to protect it is because it is unique, it is not known. So you need to ensure that it is kept confidential throughout the process of development up until you're ready to announce the disclosure and the development of the app. And just to answer a question which was asked regarding the trademark, so the question is, if a UK registered trademark is infringed, what range of costs should be budgeted to defend it? So something that you may want to consider if maybe your trademark is infringed is to contact the person who you feel has infringed your mark before you take legal action, because legal action may be expensive. So it may be best to consider writing to the person who you feel has infringed your trademark, notify them that this is a registered trademark, provide them with the registered number, and tell them to stop using the trademark. So if the practical methods are not complied with, then you can decide whether to take a legal action or not.
Question about the art project, its idea and name. Any suggestions there?
Yeah. To answer Maria's question, she asked whether she can protect her card project. So the answer is yes, but it depends, because it depends on which the art project is. If it is a paintings and it will under the copyright law, and if it is something like everywhere, like the lab, like the computer you are using or something else, they might under the protection of design law. But if you are just a drawing, it will under the copyright. So the answer is yes, but as for the idea and the name, it cannot be protected, because we cannot protect the idea itself. But as long as you use the idea in your art, and you can protect it. So if you just have some ideas in your mind and cannot apply it in your protection, maybe the answer is no. So that's how you can protect your art project.
There's a question there from Emma Johnson, who's developing a super lightweight packable dog bed. Is there a way they can protect this from larger companies starting to make the same? I believe that's open to a design question.
And I think not only design law, maybe you can also protect your protection under the patent law, because since it is like industrial protection and it is packable, so I think it can also protect by the patent. You can also fill a formal application to the IPO, or maybe you can register your design right. And I think both of this is okay. And I also think maybe if it's relating to trademark, you can also trying to protect it by trademark. Yeah.
The last question that I can see on the screen at the moment is a question about, is patenting a good idea anyway, which was covered in one of your slides. But one of the things that was mentioned here in the question is that many patents aren't granted until after the information has gone into the public domain through the publication process. Is that something that can be protected whilst it's going through the patent process?
Okay, my answer is that depends on the strategy you want. For the patents, patent law decides to have an exchange for you. They want to exchange for your invention, and they give you 20 years period of time to monopolize it. So that is an exchange. If you want to get a patent right, you need to give out and you need to make your invention to the public. So that is the price you apply for a patent. And that's mentioned that the patent is published before it's granted. That will not harmful for your novelty, because the novelty is before the date for you apply for it. So the date for granting it to apply it is about 18 months. You need to wait 18 months for granted. So if your invention has been got out in this period of time, that won't harmful for your patent. And is that the best way to protect it? That will depend on the strategy you want and how you are going to make benefits from your strategy. So that is another question to choose to protect it, like trade secret or a patent.
Thank you. That's very nicely done. Well, I believe that that is the last of the questions that I can see on the screen. And I wish to thank the panelists for presenting today. I think we've covered an awful lot of ground, an awful lot of territory. It goes without saying that if you do have an idea and you want more advice and help and support, then we are here to help and guide you in that process. And we can refer you onto the qLegal. We can give you access to the qLegal system. There is a waiting list to go on there, and you may not get a response till October, but don't worry about that. There are lots and lots of services that we can perhaps guide you through during that process. To contact us, it's quite simple. You just email UEZ, that's Uniform Echo Zebra, at essex.ac.uk, our usual email address. And we will, and that's currently up in the chat box for you. And we will deem to be able to answer you in a relatively short amount of time, but please bear with us because we are under pressure too. Once again, I'd like to thank our panelists for presenting today. It is a very complicated subject matter. And yes, my recommendation to you is always take advice, professional advice, from accredited sources. And today we've had Queen Mary University from London, qLegal presenting. You can't get more credible than that now, can you? So thank you once again, everybody, for attending. Thank you for joining us today. Our sponsors were Essex County Council today, and I thank them gratefully for their support. Once again, thank you and goodbye.